the law matters? Of course it does. Welcome once again. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program continues to provide legal information, relevant examples, and practical assistance to help you with the law matters, because the law matters. A better understanding of the law will put you in a better position to decide how to protect yourself, your family, and your business regarding law matters. As we present various topics, you may decide, in fact, that you can handle some issues yourself. If you decide to enlist professional counsel, you'll be better prepared, and so will the professional you select. Our goal, as always, is to help you save time, money, and achieve the best possible results. As always, we want to first welcome and thank Attorney David Bazar from the Bazar and Associates law firm in East Providence, who continues to provide legal information as we address various topics. And together, we would like to both welcome Attorney Kevin Nerney, who is Executive Director with the Rhode Island Developmental Disabilities Council. And he is with us today because we're going to be discussing supported decision-making. It's a tool that's allowing people with intellectual or developmental disabilities to retain some independence and autonomy and have the ability to make some choices themselves. At this point, you may or may not be aware of what the American Disabilities ADA Act is, but it's kind of important that you think about how it might affect you, someone you know, someone you love, and how it affects daily lives of so many people. How does it work? What do you need to know to protect your own rights? So let's go after it. Let's put Kevin on the spot first. So set this up, give us a little context. So what is really supported decision-making?
So it's really interesting because at the heart of it, it's just something that we all do every day. If you have to make a decision about something important to you, say it's a medical procedure. You want to talk to other people that maybe have gone through that procedure. You want to talk about which doctor should I use? Oh, you had this surgery done as well. Did you like the doctor? Did you like the hospital that you had to get it done at? So you get information from people. You get help making those decisions, and they're really tough and important decisions to make. So it's just something we do naturally. But say you needed help opening a bank account. And you want me to help you. If I go to that bank and I say, I'm here to open a bank for somebody else, they're going to say, well, no, you don't have the authority to do that. So what supported decision-making officially in Rhode Island is, it's a legal way to give somebody else the authority to assist you with making decisions. So for instance, you could give, if Deb, you wanted help with, say, a medical issue, you could make us your helpers, the people that would be supporting you in making a decision. I could go to a hospital with this signed agreement and say, I need to get Deb's medical history. Obviously, they would never give that to me if I just went in and asked for it, but with this, now I have the legal authority to get it on your behalf. I can take it back, we can sit around and discuss what the issue is, and then you ultimately are the one that makes the decision. We just help you kind of gather the information and explain it in a way that you understand.
So, David, from the legal side of it and the people that you may represent, if a person doesn't have intellectual or developmental disabilities, maybe they have some mental health issues, or maybe they're senior, getting on in years, if those things that Kevin mentions are likely to affect their lives, do they need to have, what do they need as a legal instrument to make that happen, rather than them just waltzing someone in, as Kevin was saying?
So there's actually, in Rhode Island law now, thanks to the work of Kevin and others, the ability to create this agreement that the person who has the need for support can name the people he wants to give that support. I would actually take it a step further if a client came to me with that situation, and usually they're going to come to me and say, we need to get guardianship over the older person or the younger person who has the developmental disability as they're going from being a child, turning 18, and theoretically now legally able to make their own decisions. If they're at a point where they've gone through as a child, some school that helps give them some independence, or some other transitional programs that exist, I would suggest that not only do they create the agreement that would allow having a supported decision maker, but also a couple of other documents to avoid a guardianship, because they're coming for a guardianship. And the problem with a guardianship is it takes away the independence of the person. And now in Rhode Island, we have gone to a larger extent to say, well, what do we need help with? And try to retain some independence by checking off just financial decisions or residential decisions or relationship decisions. So we do have the ability to limit that in some way. But if we can avoid the court altogether, what else could we do? So my suggestion would be, you'd also want to sign a HIPAA release, which is a document we create when we do an estate plan that authorizes the supported decision makers, so there's no question about their rights to get those medical records or medical information for them to be able to do that. I would still recommend signing a healthcare in Rhode Island power of attorney and Mass healthcare proxy, because there might be times where the person who needs to make the decision, and this can be for anybody, are unable to let the doctors know what they want. And also, we do a living will when we do that, so if there's other directives that you, as the person, want to give, can do that. And perhaps even a power of attorney if you want them to be able to do some things for you if you can't do them. So I would create a whole package of documents so that we avoid guardianship. And that would be the long-term goal.
So Kevin, you work with people who have intellectual or developmental disabilities. I think it's important for our context here. It's not just and only, there may be senior citizens or maybe someone who has some mental health issue. So how do you get to determine, who gets to determine whether someone should be or has the capacity to make their own decisions, or how does someone who doesn't have that capacity get to select who should help them make those decisions? That's a lot of questions.
So, yeah.
That is.
In Rhode Island, particularly for people with developmental and intellectual disabilities, there's a statute that plainly says that everybody has the right to make their own decisions, that as long as you understand, I believe the statute says something along the lines of, as long as you can understand the procedure when it's explained to you in a way that you can understand it, that's fine. So, but to go back to the bigger question, capacity. Everybody in the state, every citizen in Rhode Island has the capacity to make their own decisions. The only person that can say you don't is a judge. So you have to go through that guardianship process, as David was pointing out before. And I'm glad you brought it up, because support decision making really is an alternative to guardianship. That's why it was put into place, and you really did a nice job of outlining some of the other alternatives that are there. There's kind of a whole estate planning package that you do. And yeah, these things often work hand in hand with each other. There's a bunch of other like fiscal alternatives as well, like able accounts or
Account payee,
payee under the Social Security Administration. So, and this is why I think at the beginning of the show you said if you choose to seek an attorney. This is why it's probably important to seek an attorney, because there are a lot of things out there that you might not even be aware of, and so it's really important to talk to an expert. But as an alternative to guardianship, again, David did a pretty nice job. The statute in Rhode Island specifically says that we understand that giving guardianship to somebody or takes away somebody's civil rights. It says it right up front in the statute. And we want to avoid that at all costs. And that's why they can limit it, both in the areas that you can get guardianship and the kind of level of what authority the guardian has. I do want to point out that the guardianship process is a public process. It takes place in probate court. So unless it's sealed, all that information is public. Whereas these agreements are private agreements. The support decision-making, the HIPAA waiver, I often work with younger people as they're becoming adults. So a FERPA waiver, which is the education, is education specific.
What is that then, Kevin?
So there's a federal law that protects educational privacy, documents that are held by, like, say, a school, for instance. And I got to tell you, in my practice anyway, when people are looking to get guardianship of their soon-to-be adult child, it's often that they just want to still be involved. And it's almost always just as often that the soon-to-be adult child also wants their parents to be involved. And these waivers usually clear up all of the issues, because now they can still go to IEP meetings, they can still get medical information, and they can still kind of naturally help them make decisions, even without a support decision-making agreement in place.
And here's the
Good to know.
pushback you'll get a little bit. This is what you'll hear a lot. I hear it. I'm worried about their safety. Well, what does that mean? Well, I want to make sure that they're getting everything they need. Well, what does that mean? And you're exactly right. I want to make sure they haven't graduated from high school yet. They're still entitled to an IEP and all of that. I want to make sure that all of those rights are protected. And as you said, the FERPA agreement allowing them to get that information, the waiver, the medical HIPAA, you can still have all of that. And once they understand that, and they understand that they have a child who's got some abilities, let's maximize those abilities, and this is a way to do that.
Right, and so that's actually important to point out. Two things that you said there. One is the safety issue, right? What is safety? Safety is different things to different people. And I don't know about your practice, but when we talk about guardianships, I've often seen where the parents want guardianship over an adult child, but that person's siblings are like, what? No, absolutely not. And just people look at people from a different lens. I'm a parent. Obviously, I'm always worried about my children's safety. And that kind of leads to the next thing, which is making decisions. And you have to make decisions to know how to make decisions. And sometimes you have to make bad decisions to know how to make good decisions. And so you kind of grow up. If the more decisions you're allowed to make and the more autonomy you're allowed to have, the better you get at making those decisions. And so that's why it's really important to start at a young age. Right. This is one thing with IEPs, and I know I'm going a little off topic here, but if there's a kid who has an IEP, if they're in like high school, for instance, I would have them bring a friend to an IEP meeting, not just the parents. Obviously, the parents should be involved as well, but have them start involving other people and letting them make those decisions at that point. I think that can be really helpful.
Yeah, I agree with that. And just to go back on the bad decision making, as a parent, we all want our children to make good decisions. But what do they say? You learn more from making a bad decision sometimes and hopefully learn from doing that. And it doesn't matter, as long as they're safe and it's not like a terrible decision, sometimes making a bad decision is a good way to learn.
Is that not what the ADA first thought of? It would be a good idea for people to have rights. They do have rights. The ACLU wants them to have rights. How does a younger person growing up get to know what they don't know? Who helps them along? Are there organizations that help them along so that they can learn that by the time you're 18, if you want to vote, you can vote. If you want to be living independently, you can, and we can help you do that. How does a person who's in that position get to learn?
It begins with the parents. It's always going to be with the parents. But then again, siblings, friends. This is why it's so important that that kids in schools are integrated into the school system. That they're not in classrooms where they don't get to interact with the whole community. And it's really important for the kids and for the rest of the community. So that's where you start to learn these skills. It should start at a young age. You should be involved, and parents and siblings and friends and schools, and everybody should be fostering that as well.
Are those the
and
people?
Teachers too.
And teachers.
Because it's, this goes back to when I was president of the bar and I wrote about teaching our children, teach your children well. Little Crosby, Stills, Nash and Young reference there. But I was very big into teaching civics and understanding your rights and the responsibilities of being a good citizen in voting and having all of that is not just for a child who needs to have help making decisions, but for every child. So that's just to go back, where do you learn how to do things? Your parents, your friends, your siblings, your teachers.
And what I had asked earlier about who becomes the supportive decision makers, these friends of parents, teachers, whatever, are these what might form the team that someone might need going forward? Or how does that evolve?
So it evolves differently for different people.
Certainly.
And having a community of support is really important, especially for people who are going to need assistance with making a decision. And in Rhode Island, for instance, we do have some people that receive services through the Division for Developmental Disabilities who don't have any family or any community support. And when a decision has to be made, say they need a medical procedure, if the doctor or hospital believes that they don't have the capacity to make that decision, there's nobody there to assist them, and the state has to step in and go through a court process. Right. It's really invasive, and so we want to avoid that as much as possible. So we want to build these communities of support, and it starts younger, but it can still happen as an adult too. You know, as David was saying, by allowing people to make decisions and be a member of the community and make sure that they have community assistance, they can build that capacity as they go. So for instance, if somebody might need a guardianship, we were talking about this earlier, somebody might need a guardianship right now, and the judge may say currently they're in need of a guardian. But through the process of assisting them in making decisions, they may at some point no longer need a guardian.
Right.
I don't know if you want to.
Yeah, and I'll just expand on that. So I was a guardian ad litem in a case, and my recommendation was that this was a developmental disability situation, and the child was actually going to be going to a program where they would transition to learning to how to be independent and make decisions. They weren't there yet. So I said, right now, yeah, guardianship's appropriate. I think, and here's the best part of it. I spoke to the child, and I said, what do you think? Do you need help making decisions? Yeah, I do right now. And the child expressed his preference for who would help make decisions. But when we talked, and he's talking about the program and what it would do for him and where he would be, I said, at some point in time, do you think with some help you'd like to be able to make your own decisions? And the child said, of course, basically, yes, that's where I would like to be able to end up. So I wrote in the report that, first of all, this is where the child's at, but look at this again when the child's done with the program and think about entering into a supported decision-making agreement and letting the guardianship close, because I think that's the goal for anybody who can get to the point of being independent with some help. That's what we would want to strive for.
So when we talk about supported decision-making, you touched on a couple of the topics, the healthcare issue, maybe it's in education, some have an IEP, might need help going forward, may not. There are other issues, you touched on financial briefly and going into a bank, opening an account. Housing, I understand, is yet another occasion where supported decision-making would come into play. Can you give us an example of how that might work?
Yeah, housing's a really big one. I actually had a client I was defending against the guardianship. He wanted to move to Providence, and his father did not want him to move to Providence. He thought it was a little too dangerous. Safety issue, right, was the big thing there. But he was able to have some siblings, mostly, that were able to get information on places to live, neighborhoods, safety data, that kind of thing. This was before supported decision making was an official thing, so this was just kind of the natural process. But they were able to kind of gather all that information, present it to both him and his parents, and eventually came around to saying, okay, I guess it's okay for you to move to Providence. And so
Did it avoid the guardianship?
It did, yeah. Yes. Yeah, it was during a guardianship process. Guardianship was not granted, but the parent eventually came around to saying, oh my gosh, this was actually a better process anyway, because it helps maintain that relationship. Right. Guardianship, now you're not a parent-child relationship anymore. Now you are ward of the state and actor on behalf of the state. Right. So,
and it can have inherent conflict sometimes when somebody has, as this person did, who would have been the ward, some thoughts and ideas as what's best for them. And it's not what other people think's best for you. And as you said at the very beginning, it's a civil rights issue. You lose control over being able to make your own decision as who you're going to associate, where you're going to live, how you're going to travel.
Yeah.
So you do family or unfamily court, divorces and things at times. And divorces come as a result of people who have unresolved or irreconcilable differences. When you end up with conflicts of, yes, I should be a guardian, no, I don't need a guardian, does that end up going from a probate situation to a full-out war and litigation and how does that play out? Because I'm sure that when it comes to relationships, that's always a hot button for people. If they have a
I don't know
disagreement.
about you, but I've actually seen it usually goes the other way, where the divorce happens, then they continue the divorce proceeding in probate court,
Yeah.
going for a guardianship.
Absolutely.
Where
And
either
they
they
become-
each parent wants the guardianship, or one parent wants it and the other one doesn't, or whatever. But
Right.
it's oftentimes just an
Or
extension
they're
of-
arguing about who should be the guardian.
Yeah.
And that type of thing.
and it's an extension of the divorce proceeding, really.
Correct. It really is. And so the answer to your question that I think you were asking, not sure, but it's family court has jurisdiction over guardianship for children where there is a conflict. If there's an agreement, then probate court could have a guardianship for a minor, but usually if there's not an agreement, that's a family court jurisdiction. Obviously, when it's no longer a child, it does, as you said, move to probate court and the family court case continues.
So let's talk about work. There had been discrimination. ADA tries to help that so that there is not discrimination in the workplace way back in 1990 as I read about it. So now people want to work and they can't quite do the 8 to 4:30 or whatever. There are some adjustments that are made. They call them reasonable accommodations. How does that come into play?
Yeah, so the ADA, like you said, was signed into law in 1990. There was a case called Olmstead. You'll hear a lot of people say states have an Olmstead plan or that's an Olmstead violation. The important thing is there was a Supreme Court case with the name Olmstead which essentially said that people have the right to be part of their community and to live in the community. And that has been expanded to kind of every aspect of life. So 10 years ago, a little less than 10 years ago, Rhode Island was sued by the Department of Justice because people with developmental disabilities were going from essentially a closed classroom to what we call a sheltered workshop, where it's all people with disabilities, they're doing piecemeal work, and they're being paid less than minimum wage. Some people were making 5-8 cents an hour. And it was pretty bad. Olmstead applies to that as well, and that's through the ADA. And obviously, people need to, just like when they're making decisions and choices for supported decision making, you need work experience to know what kind of work you want to do. So you don't just drop into a job and that's it for life. You know, you hopefully get a lot of different experiences, and so that's where we're at now, is trying to make sure that people have the ability to live in the community, to try different types of employment and that kind of thing. And supported decision making obviously can help with the employment process as well. What do you like to do? Doing some real like person-centered planning and focusing on what they like and what their interests are and what they're good at. Focusing on strengths of the individual so that they can be employed and part of the community. And so, yeah, that's absolutely something that we focus on. One of the things you mentioned is somebody might not be able to work the 9 to 5, which is what the first thing everyone thinks is a 9 to 5 job. And it's funny because when you look in the community, most people I don't think actually work a 9 to 5 job.
That's
There's
true
second
now.
shift, there's third shift.
Yeah.
People obviously, since the pandemic, working from home.
Right.
So there's lots of accommodations already out there and available. And so, yeah, we seek to show employers that you can get a lot of benefits from hiring people with developmental disabilities, and you might need to make some slight accommodations. And for the most part, the employers have been very interested, and more people with developmental disabilities have been employed since that court case.
Yeah.
But we still have a pretty long way to go there as well. One of the other things you had mentioned around the 9 to 5 is something called customized employment, where you actually carve out a specialized employment relationship for an individual so they can fit right in there. And that all connects kind of to the supported decision making. Like I said, it's a formal agreement to help avoid guardianship, but it's also just something we naturally use in our daily lives.
Right. When you make decisions without it, you're still going to need to gather information so that you can make an informed decision, as we would say. And so this is just a way of having people who can support you to get that information so that you can make that informed decision.
An interesting facet in reading about this is that technology can provide assistance that promotes and encourages and enables independence. And I'm not sure that anybody necessarily first thinks of their smartphone to be anything other than how they're going to be maybe taking care of their appointments and making a phone call. And yet I think you've had a couple of occasions that you've spoken of where technology could actually help somebody thrive on their own.
Well, I'll tell you what, I probably wouldn't be here if it wasn't for my phone. I would have either not seen it in my calendar, which was there. It has the GPS to help you get here, so I literally might not be here without that technology. But absolutely, technology can help people make decisions and remain independent. And so, that should all be part of the process when someone's planning out their life. But it could be as simple as, ding, reminder to start making dinner. Ding, reminder to take your medication. Right. It could be the kind of technology that assists someone with starting an oven, with checking in on loved ones, that kind of thing. So technology is amazing right now. There's stuff that I'm not aware of that's out there that all can be utilized to make sure that people can live independently.
Yeah, so for example, I think it's called FaceTime. I'm not very technologically, I'm challenged. But if you had someone who just was now living independently and you wanted to make sure everything was safe, you can FaceTime and look and make sure they've got what they need. You have the conversation. And as you said, reminders are very important, especially not just for people who are younger and now starting to live on there, but for people who are older and may have some memory issues. To maintain their independence, because as you said, this isn't just about developmental disabilities and young, but for anybody who might need a little help making decisions.
With the little amount of time that we have left, touch on, if you will, the idea about voting. So people have a right to vote. How does supported decision-making come into play with that, or does it?
It certainly could. We all have, maybe we all don't, but we all have discussions about politics and who's running there and but some people don't like to share how they're going to vote too, so it kind of can go both ways. If you're open to it, sure, go and get all the information, have somebody assist you with that. If you don't, though, we also have to focus on making sure that people, their privacy is respected when it comes to voting. One issue in Rhode Island is on the application, it actually says, I have not been adjudicated to be incompetent to vote. So a lot of people think, oh, I have a guardian, so I can't apply to vote, and that's not true. We're working with the state right now to change that language so that it's not there anymore, so that it's very clear. And they have been helpful and said, yeah, we'll try to.
The Secretary of State's office has been responsive to a lot of things that are brought to their attention like that. So the language is a little vague and unclear as to who has the right to vote with the declaration of incompetency, perhaps like from a court to stand trial, that type of thing, or whatever. They need to be more clear as to what it is and who it is that's allowed to vote.
That's good. Thank you, Kevin, for joining us. We thank you for tuning in to The Law Matters. We're here to help protect your rights. We're glad that you tuned in. Stay tuned to Law Matters. It matters to you.